Welcome to our podcast, Faculty View from CWRU. Today we are going to talk about a hot topic in patent law, the patentability of marijuana. My name is Sarah Siedlak, and I am currently a 3L at the law school and also the managing editor of Case Western Reserve Law Review. Today I am joined by Professor Craig Nard, who is an intellectual property teacher here at Case Western and also the director of the Spangenberg Center for Law, Technology, and the Arts. Thanks for being here today.
My pleasure.
So one of the first questions I think people might have is whether or not you can actually patent marijuana.
This is a logical question because you cannot patent things that are naturally occurring. So you can't patent Mother Nature's work. But in a very famous 1980s opinion by the United States Supreme Court, and you know this well, Sarah, having gone through the class, Chief Justice Warren Burger held that the fact that subject matter is living or not living doesn't matter. The key is, has the inventor altered nature's handiwork to such an extent that the resulting invention is sufficiently different or markedly different, to use the court's language, than what occurs in nature? So from that opinion forward, something that was living is eligible for patent protection. Doesn't mean it ultimately will be patented, it just means it's eligible. But the key is to alter it to a significant extent that we could look at it and say it's no longer a product of nature. So with respect to marijuana, cannabis has been around, we've known it for 5,000 years, from China on. What has changed? Well, breeders and researchers in this space, and there's deep science behind it, the cannabis genome has been sequenced. What these breeders have done is alter the particularly naturally occurring cannabis sativa and cannabis indica, to such an extent that they have different strains. And so they alter the THC level, which is the psychoactive ingredient. Sometimes THC is removed or reduced greatly. And now what you have are many, many strains and resulting patents on these strains that could be used for medicinal purposes or even recreational purposes.
Okay, so there are ways to potentially patent marijuana. But doesn't the USPTO, the Patent and Trademark Office, care that marijuana is still illegal under federal law?
It doesn't. I shouldn't say it's indifferent, but it's not in their mandate. So unlike European patent law, which has exceptions for that which is against public morality or immoral, or even American trademark law, which denies marks on scandalous or immoral trademarks, the American Patent Office is unapologetically amoral and non-judgmental. And so the Patent Office will treat the mundane, whether it's a can opener or a bicycle, equally to that which is more controversial. Say the marijuana strain, or birth control devices, or transgenically constructed mice. It doesn't really care. So it has built into its mandate this sort of amoral, non-judgmental quality. And so what you will see is patents issuing on things that where the public would say, how can that be, right? Particularly if they are controversial from a social perspective.
Very interesting. And then there's another related issue to that, in that you have two government agencies that kind of seem to be on the opposite ends of this issue. So you have the Drug Enforcement Administration on one side, saying marijuana is illegal, still enforcing the laws. And then you have the PTO on the other side, handing out patents, which are exclusive property rights for this. How can that be?
That is a question I think that the courts eventually will have to address. So the DEA, which is part of the Department of Justice, the Patent Office is part of the Department of Commerce. They each have their own rules and regulations. It is true, as you suggest, that the DEA has categorized marijuana as a Schedule I drug, which means it has no medicinal use, which is interesting that it's still categorized that way. But heroin and LSD are also in this. And so you can't write a prescription for marijuana. You have the Patent Office saying that, well, we're going to issue a property right on these different strains. And so how can it be that one agency, as you suggested, in the federal government, could grant this powerful, potentially powerful right to exclude piece of personal property, and another part of the government saying, well, you really can't do anything with it in terms of selling it and marketing it. And so right now these two agencies really don't communicate, and you have this interesting situation where one agency says it's okay within our purview and another one saying it's problematic in ours.
Very interesting. And what effect do you think all of this will have on the market?
So a potential conflict is, so while these two agencies have their own distinct rules and regulations, what happens if they were to come into conflict? So for instance, as you know, growing and selling marijuana is legal in many states, right? Several states recreationally, many more for medicinal purposes. The Obama administration sort of stood down and says, let's see how this experiment works at the state level. So while that's going on, what happens if a patent issues to a particular breeder or company, and that patent owner says, you know, this grower in Colorado is infringing my patent rights? What results? So if we think about a few scenarios, let's say the patent owner approaches the breeder and says, stop doing what you're doing. What's the breeder's likely response going to be? The breeder says, well, what I'm doing is perfectly legal under state law. The patent owner says, well, patent law is exclusively federal. So the patent owner sues in federal court. Is the patent owner likely to win, assuming there is infringement here, right? If I am the breeder in Colorado, I may say, well, wait a second, you're suing me on a substance that you will not be able to market or make under federal law because of the DEA. What's the patent owner's response? The patent owner may say, well, look, I may not be able to market it under federal law, but my right is a right to exclude, not a right to make. Therefore, I could still enjoin you under federal law. We don't know how that's going to play out, but that is a potential conflict. And meanwhile, you have all these patents issuing for some reason, and it may very well be that these patentees and patent applicants see the trend lines and are thinking, well, one day the federal government is going to reschedule marijuana, Schedule 2, Schedule 3, whatever it may be, and when that day comes, that will be well positioned with our right to exclude, and then that will be a different dynamic. Before that happens, you have this potential conflict. So I'm not sure you're going to see litigation, but you have to think what that scenario is going to be.
An interesting problem, and I guess we'll see what happens with it. But thank you so much for sitting down with us today and shedding some light on these really interesting issues in patent law with marijuana.
It's been my pleasure.
And thanks to you for watching.